Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello and welcome to the program. My name is Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria. Ladies and gentlemen, this program brings the very best topics to discuss, primarily to kickstart your consciousness. Before I start, it is important to let you know that what I say here are not legal advice. Therefore, you must not act on them, but rather take the telephone on the screen to come in for a very detailed consultation. At that stage, you can act on what we advise you. Ladies and gentlemen, the telephone numbers on the screen. We are a legal aid firm. We also represent you at the police station free of charge, from the police station in any police station in England and Wales, all the way down to the magistrate court, to the crown court, in any court, England and Wales. Ladies and gentlemen, and also we avail you the opportunity in areas of employment, areas of family law, areas of county court matters, civil proceedings, so that you can have all in one: litigation and advocacy. As a matter of fact, before litigation, that we have given you a much better negotiation to get your result without going into litigation. This is all encapsulating and all one-stop shop for you. Let me crack on my topic today. I'll be discussing today updates on Article 8, update on Article 8 depreciation, updates on Article 8 depreciation, update on Article 8 depreciation. I want to start first by building the foundation and building the history and chronology of how we got to Article 8, or the changes, especially the hurricane of changes that took place, that Article 8 began to have a watered down application. From July 2012, July 2012 marked a very significant change in immigration rules and policies. Mark this date: July 2012 was a hurricane of changes from the Home Office. By presenting before the Parliament immigration rules which changed quite a whole of holistically, as a matter of fact, overhauled all the previous practices that was going on before July 2012. That July 2012 changed quite a whole lot of scope of applications, from point-based system applications, student applications, entrepreneur applications, visitors applications, whatever application under the immigration rules, as long as it's concerned. That July changed it. However, the petitioners like us, the firms like us, have continued to interpret and question that immigration rules, which is why you see a lot of plethora of cases, a lot of decided cases that have been chunked out by the upper tribunal, High Court, Court of Appeal, Supreme Court, as it relates to matters post-July 2012. Now, those decisions have been either to, in one way or the other, ensure that Home Office have changed the immigration rules, obviously, or ensure that the policies have been amended or the guidance is amended. And also the statute also amended. Now, all the way down to the decisions handed down by the European Court of Justice also make changes and sweeping changes to the policies and immigration rules. But nonetheless, the immigration policy and immigration rules of 2012 upwards brought a whole new lot of changes. It brought, as a matter of fact, in my simple analogy and conclusion and summary of those changes, it brought a whole lot of restrictions in immigration applications. It brought a whole lot of strictness in whole application, immigration application. It streamlined the sort of application that ought to be made in whole of application as regards immigration. Those changes also were a little bit sometimes draconian, especially when it comes to partner life between husband and wife. That changed from 2012 in respect to financial requirement has recently been endorsed by the Supreme Court. But all the changes and all these challenges as to show that that particular requirement of financial obligation of a spouse, as a sponsoring spouse, to have in order to sponsor his or her partner. Now, that figure of 18,600 has been challenged from the first year to the upper tribunal to the Court of Appeal, currently by the Court of Appeal. Supreme Court recently in 2017 has ruled, late 2016-17, has ruled that that figure, 18,600 required of a partner, sponsoring partner, is valid. However, which is very important as well, the Supreme Court made some amendments to that, which is why I told you that policies and guidances and immigration rules are subject to challenge and interpretation. And unless you take that decision to go forward, then obviously you only have to get whatever you get from the first decision of the Home Office and to walk away with it, which is not the right thing. So building on from that 2012 decisions of the changes in immigration rules, it moved on to 2016. Now, let me take that further again. From 2012, the immigration rules changed in 2014. So Immigration Act 2014. So Immigration Act 2014 came into place and then moved to 2016, Immigration Act 2016. From December 2016, a lot of changes has also taken place. Some of these changes are consistently a bottleneck. The Home Office consistently started from the base of the bottle and started building it in form of a pyramid and started streamlining it as it gets to the tip, at the point whereby it will consistently and automatically close up. The pyramid stayed from the base of it, which is open. The base of the pyramid or the base of the bottle had been the practice of the immigration rules and practice and policies and guidance pre-2012. That means it was broad, very easy. It was consistently friendly. However, the Home Office has started consistently to streamline those policies and immigration rules in a pyramid form to such a way that it's almost getting to the tip whereby there is no more exit. There's no more work to do other than sealed completely. And they're getting there. How are they getting there? At this point, we are still in the bottleneck position whereby it is still going further. The higher you go upwards, the thinner it becomes, the harder it becomes, until they finally adopt the pyramid shape whereby it gets to the tip. There's no more room to expand, no more flexibility in that particular top. That is why we are challenging some of the decisions that are going on now. Part of the decisions and part of the requirements and part of the circumstances that will lead us to meet the pyramid shape is the Brexit. The Brexit, whereby the Home Office, the United Kingdom, will pull out completely from obliging itself with the requirement of Article 8, or that is the Human Rights Act. The Home Office, the United Kingdom, will now exchange that to the Bill of Rights Act, made for the United Kingdom alone, not applicable to any European country. As a matter of fact, the Brexit has started. The draft of the Bill of Rights has also started. There's quite a lot of changes taking place when it comes to that. So we are closely monitoring those Bill of Rights, the contents of the Bill of Rights, whether at all it will be consistent with the Human Rights Act, which the Home Office have promised that it may be consistent. It's just a matter of changing the name. But however, this will now be completely in such a way that it is only applicable and specifically applicable to the United Kingdom. And in that case, that vast flexibility that European Convention on Human Rights gave will not be streamlined and almost exhausted or almost extinguished. Ladies and gentlemen, that is the process we are getting to. Now, Article 8 is getting hammering. Article 8 is the right to family life and private life. Article 8 is two portions of it, the family life portion and the private life portion. The family life portion, which most of you rely upon, has continuously come under great scrutiny, that it is consistently depreciating. That's why my topic is update on Article 8, depreciation. Why did I say so? 2016, cases have come before the Court of Appeal, which is the Court of Record, and lately to the Supreme Court, in decisions bordering on Article 8. Decisions bordering on Article 8 is very dicey. Naturally, cases of Article 8 should be considered on case-by-case basis. And that is what it is, which means the circumstance of A is not the same thing as B and not the same thing as C. So they all have to be taken into account. But since these days, from 2012 all the way to especially 2016, it has been a shift of a blanket refusal, whether or not your circumstance is different from A, B, or C. There's been a blanket refusal. So articulate which has been the right to protect your family life. However, the first portion of that is your right to protect family life. But Home Office is consistently hammering on the second portion of the subsection 2, which means is the right subject to certain conditions that it could be also violated. Now, they are also releasing so many dimensions of the updates of the article of the Immigration Act 2014 that have released quite a lot of changes, which I said to you, and also in 2016 as well, a lot of changes in the Immigration Act of 2014 and 16 has come into a place to give a great number of arsenal in hands of the Home Office to consistently trample upon articulate, whistle and articulate, and completely extinguish articulate as applies to you. Now, when they make such decisions in line with other sections of the Immigration Act 2014-16 going forward, the Home Office will present the decision as being reasonable. And in that case, the question for interpretation before the court or tribunal is the reasonableness of the decision of the Home Office. When it relates to your articulate, when it relates to your articulate, when it relates to your articulate, the proportionality of that decision as it relates to your articulate. I can see that 5 years ago, as I said, 5 years ago, prior to 2012, clearly articulate, even after 2012 was enacted, the immigration rules of 2012 was enacted going forward. As a matter of fact, post-2012, July 2012, there was really no much changes, or the Home Office were not really so much adamant in applying the changes as it relates to articulate. They were very fluid and very flexible when it comes to articulate application. But lately, as time goes on, matters come before the first upper tribunal in decisions, obviously from the first tribunal. The Home Office has consistently challenged any decisions made by the first tribunal, allowing your appeal under articulate, and obviously marrying it with the rules as to whether or not the decision was reasonable or not. As a matter of fact, the jurisdiction of the first tribunal or the tribunal in general will only be on the basis that the decision is unreasonable and the decision is not proportionate. Now, when they bring this to before the court will interpret the reasonableness of the circumstance and the decision, and also the proportionality, which is very important in decision-making process. They are very crucial to fuse them together in order to provide a decision that will stand the test of scrutiny as long as legal challenge is concerned. Ladies and gentlemen, Tice Madox Solicitors will consistently look through this, your circumstance, to ensure that the reasonableness application is infused in your application and the disproportionality argument also infused into your application. If you do not know how to argue this, then obviously why don't you come to the expert that know exactly what to do for you and to achieve result for you and give you 100% chances of success as your case is applied, as the case goes forward. Ladies and gentlemen, I'm discussing update on articulate depreciation. Depreciation has consistently on articulate continued to be watered. Now, let me rewind back and tell you why this decisions articulate has been watered down, especially when it relates to the right or the family life between spouse, husband, and wife. That almost has been thrown away from the window. Yes, that decision and that circumstance between husband and wife almost have been thrown away from the window when it comes to articulate argument. As I said before, 2012 I continuously battered and constantly taking a knock on articulate, consistently drumming it down in such a way that if it could have the chance, it could even argue that it does not apply to you. In certain circumstances, the caseworker will even make a decision under eligibility criteria that even if you claim to be the husband or wife or partner or civil partnership or partner of this person, that you're not eligible because your relationship does not even exist. So on that basis, once they attack your relationship, it does not exist anymore. Therefore, your Article 8 will fall down flat, which means you are not even in any way related. You're not in any way in a relationship. That is what the caseworker argument will come on. No matter how infinitesimal, no matter how useless that ground will be, no matter how unreasonable that decision will be, but they were happy to say so that you are not even in a relationship. And in that ground and in that manner, we refuse the application and give you a right of appeal out country. You see the technicality, you see the plan, you see the way the Home Office makes the decisions and make things very difficult for you. And that is why before they even argue about your eligibility of the relationship, why don't you come to the expert who will first of all make sure under the criteria and the requirements which you are applying that you meet all of them, that whatever is not there. Listen, what we do is that when we consult with you and we're making an application and arguing for you, we send you to get the information and documents that are required. Some of these documents, you have them, but you don't know how to place them. You don't know how to extract them, but we'll tell you how to extract them. We'll tell you how to get them. We'll tell you when to get them. We'll tell you how to present them. Ladies and gentlemen, that's what Tice Madox Solicitors stand for. The best in legal matters. We eat law, we sleep law, we research law, we talk law, we work law. Everything we do in Tice Madox, as a matter of fact, Justice Maduforo, whatever I do is anchored and pivoted on law. Nothing more, nothing less. And therefore, we present that. We transfer those expertise in your circumstance. How about that? That is crucial. That is fundamental. That is on point. That is the beginning of a success in an application that you want to lodge. Not only in immigration, ladies and gentlemen, please do not put us on just immigration. We are expert, and our stamp on authority on legal matters go beyond immigration, applicable to employment matters, which we are dealing consistently at this point in employment appeal tribunal, and also even dealing from the foundation when your employer have given you that letter, that disciplinary letter. That's where it starts from. That's the foundation. Don't run it alone and run on emotions. Come to Tice Madox Solicitors and we'll be able to present your case on legal basis so that even your employer will be able to sit back and say that this person has a good case. Therefore, let us decide and upturn our decision either on appeal stage or by the disciplinary panel stage. That's the employment matter for you. And then we also stamp our authority in county court matters. County court matters, litigation general, litigations against your landlord, litigations against your tenant, litigations against your business partners, litigations related to will litigation, conveyance litigations, whereby there's a contract dispute or your other party had not fulfilled the obligation to the contract in respect to the buying and selling or by leasing of that commercial contract, then you can have us to do so for you in the county court, argue the matter properly, and advise you whether you have a chance or not. Most importantly, most of you run blindly into the court without knowing whether you have a case or you don't have a case. Some cases are not actionable. Some cases are not. But you run blindly on that. And when you run blindly, you incur cost against you, against yourself, from the other party who has represented and defended the case and win the case against you. Because from the beginning, ab initio, you do not have a prima facie case to go forward. Tice Madox Solicitors will unpack your case and decide whether your case is actionable or not. If it's actionable, the percentage of success in that litigation that you're going through. Please pause, rewind back, and come to Tice Madox Solicitors to take that process, which you are doing by yourself, and put the significant legal touch and expertise touch on it so that you could know whether to move forward or proceed with the proceeding or to step back forward and then think twice and have all the concept of cost or the concept of appeal or the concept of grounds put together for you to understand how to proceed further. Ladies and gentlemen, I have just moved away from immigration. I just telling you clearly, Tice Madox Solicitors are armed and fully equipped in matters which I've mentioned: police station, magistrate court, crown court, court of appeal, Supreme Court, matters in criminal, matters in family, matters in employment, matters in county court, matters in landlord tenants. Ladies and gentlemen, and this matters also includes some of you who have issues with the universities, in terms of your degree awarded, and which does not conform with your legitimate expectation of your expected degree, which you expected to come from the university. We can all also argue that for you on your basis. Ladies and gentlemen, back to the topic, updates on Article 8. Update on Article 8, depreciation. Why am I saying that? It is consistently depreciating. The timeline for Article 8 in terms of anchoring on it and in terms of succeeding on it is consistently dwindling down. It is consistently dwindling down, hammered down by the caseworker's decision, relying on reasonableness, relying on proportionality test, and they have been doing so even when they did not even apply the proportionality test properly. So our grounds of appeal, our grounds to challenge that decision, is also anchored down on the explanation of what constitutes reasonableness, and also on the ground, also what constitutes proportionality, whether the test has been properly applied in your case. When it is not properly applied, then therefore the court will set aside that decision of the home office and then uphold your appeal. That is what we stand for. The Article 8 of the Human Rights Convention of Human Rights is completely taking a stand taking a stand before the tribunals. And the tribunals sometimes are becoming wary to uphold because a lot of cases are hinged on Article 8. The tribunal is also a little bit wary to uphold one Article 8 in certain circumstances in such a way that it will be broad. So when they make decisions allowing applications under Article 8, they specify it to the case before them. They specify before the case before them in such a way that does not give hope to people outside to rely on that and then come and surge to challenge even the previous decisions they made to upturn it or even upturn the home office decision. So because of that, it becomes a very difficult task to present, which is why expert knowledge and expert touch is required in your case-by-case basis to upgrade, to escalate, and to present your articulate circumstances, argue it properly in such a way that it will stand a chance of success. That's what we do for you at Tice Madox Solicitors. Ladies and gentlemen, I'm into it. I'm into it, what I'm saying to you now, because I know some of you, based on our experience. Listen, when I talk to you in this program, I do not talk to you theory. I talk to you practical. Because why am I talking practical? Because this is what I deal with on a day-to-day basis. And therefore, you are getting information from an expert knowledge. But remember, it is not legal advice. But it just kickstart your consciousness to know the right place to go, to know that you don't sit on your right, to know that you don't sleep on your right, to know that you don't slumber on your right, to know that you can make a presentable challenge against decisions against you in your immigration and other matters, and know that you have a firm that can ride with you all through to succeed with you all through. Ladies and gentlemen, I am ferocious. I am thorough when I deal with matters for you. I make no mistake about that. I am the best when it comes to legal matters in this United Kingdom. I make no mistake to say that. And I have no apologies to anybody as I say that, because I put a signature touch to what we do. And you can stand and you can put our documentations, our representations, our arguments before any scrutiny, and it will scale through 110%. Because we take time to make sure that we narrow down the issues, we make sure we narrow down the issues, we make sure we hammer it based on the case laws, and also to make sure that you have a case to start with. That's what we do for you. Then you must not say you have excuse. No more excuse. You have no excuse, but to ensure that even if it doesn't apply to you, certainly if immigration doesn't apply to you, of course, criminal matter applies to you. We're not saying that you are committing offense, but you may peradventure be the ones who've been questioned, or even as a witness at the police station. Therefore, it applies to you. It might be your word, your children, applies to them. They probably may be innocent, but because they are nervous, they don't understand what to do at the police station. They were completely enveloped by the intimidation at the police station. They get carried away. They admit things they shouldn't admit. They agree to things that has no evidence against them. Therefore, at the police station stage, we'll capture it and we'll present it properly for you. Articulate depreciation. Now, recently, the Court of Appeal has now made a decision. And that decision of the Court of Appeal is also hammering on Article 8. More especially, Article 8 loses its stand when it comes to deportation matters. Often or not, Article 8 loses its flavor when a deportation matter is involved with the appellant. Once a deportation is applied or is ongoing, it becomes a very Herculean tax, becomes a very great tax to accomplish, to surmount deportation by way of articulate argument. But surely it is an arsenal in the hand. Because it's an arsenal in the hand, it could be expanded based on technicalities. Article 8 are either broad or argued on technicalities. Tice Madox Solicitors will know when to switch from the broad argument to articulate and switch over to a technicality-based argument on articulate. When it comes to removal, when it comes to deportation, as a foreign criminal, whether offense is committed more than 12 months imprisonment or below 12 months imprisonment, Tice Madox Solicitors will argue that for you. And that's why we'll stand with you and we'll stand for you. Ladies and gentlemen, I'm discussing articulate depreciation. And that is the decision of the Court of Appeal recently in the case of Akinyemi. It's a Nigerian case, a very interesting case, which we'll be following. Ladies and gentlemen, the upper tribunal has ruled. This is a man who has lived in the United Kingdom for 33 good years without living in the UK. But still, that's why I said that Article 8 is taking a serious hammering, because having lived in this country for 33 years, having not left here, born, as a matter of fact, he was born in the United Kingdom, have not left the United Kingdom for once to his native country, Nigeria, where his parents come from. So he was born and brought up here for 33 years. So ordinarily, he's expected to be a British citizen. But that was not the case. He was not registered at the time. So that to be a British citizen. So the parents for that 3 years didn't know what to do. 33 good years, this man was in this country, have no status in his hand. He was born here. So the parents went on the belief that it's a British citizen without making the necessary step, without meeting solicitors like us to guide them and protect them. This man has gone to commit more than 20 criminal offenses and has 20 convictions in this country. Then it comes to deportation. Now, ladies and gentlemen, with the exceptional circumstances that were always fused in when Article 8 challenge is brought to fore, one could expect that 33 years in this country is exceptional circumstance, does not speak in a language other than the English language where he was born to, could at least stand up for this young man. Ladies and gentlemen, the upper tribunal refused that and said that there's no exceptional circumstance involved. That is absurd, that's perverse, as long as I'm concerned in that decision, and that was wrong. Rightfully, that decision was challenged to the upper tribunal, to the Court of Appeal. The Court of Appeal has recently, just this month, April this month, 2017, made a decision, obviously on argument on unlawful residence, made interpretation to that, and then reverted the matter back to the upper tribunal without even touching on the basis of that exceptional circumstance finding of the upper tribunal, which means that I reverted the matter back to the upper tribunal to decide on issue of unlawfulness alone, not on the issue of the exceptional circumstance which applies to this young man. That's why I said to you, Article 8 depreciation is going further down, in the sense that exceptional circumstances sometimes don't inject further. But that does not mean that this case would not resurrect back after the upper tribunal make a decision and revert it back to the Court of Appeal again, or make a decision, arguing better now, being that the first decision of the unlawfulness of this young man in this country has now been decided and interpreted differently by the Court of Appeal. In that case, the upper tribunal will be able to look at that error which they've committed and answer the question of the exceptional circumstances that applies to this young man. Ladies and gentlemen, articulate depreciation is very key. Whatever circumstance you are, you're living here in this country, you've not made an application, even with your spouse, and you made application before and refused, and you know that upper tribunal will not, even if you've gone further, upper tribunal refused and said it's reasonable for you to leave the country because of the fact that your British citizen wife or British citizen husband or indefinitely leave to remain settled husband or wife who can remain in this country, and even if a child is involved, and they also uphold the decision of the Home Office. In that circumstance, even if you got to the upper tribunal, you do not know what to do. Revert back to Tice Madox Solicitors so that we can take the case holistically and go through a technicality to argue that matter for you, to sustain your case and put it live again. Because the meaning is that if you leave this country to go back to Nigeria to apply, or back to your country to apply, to go back to Congo, Cameroon, whatever country outside of the EU to apply to come back to the United Kingdom, it will be a huge tax, almost an impossible tax to do to return back here. Ladies and gentlemen, therefore, let's fight it on. Tice Madox Solicitors will be here to fight it on with you. We are ready to fight it on and present your case all the way. Time does not permit me to go further again. Till next time I come your way, I ask you to go to our YouTube page, Tice Madox Solicitors, subscribe there, and also add us on Twitter at Tice_Madox, and also our Facebook page, Tice Madox Solicitors, and obviously go to our website, ticemadox.com, and also view all that we need. Take the telephone number on the screen, save it on your phone, pass it to whoever that needs it, and send them to the right place that would represent them in their best interest. And we will sit down, analyze your case, present it to you, and give you the right advice you can depend, you can run on, and you can quote us. Till next time I come here, where I remain your preferred solicitor, Justice Maduforo, and obviously your preferred firm, Tice Madox Solicitors. Be strong.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields.